it's not a matter for trial within us, before us. But we appreciate that if such evidence were brought before any court, as they allege and proven, they need to be very serious consequences. As a lawyer, you're aware of that.
I have two answers to that, my lord, with your permission.
Can I supplement? There is Oscar Chihika's affidavit, paragraph 30 and 31, which talks about the same thing. And you have not replied to it.
My lord, I thank you again. I have previously, in a similar allegation, made submissions with respect to Mr. Oscar Chihika. And that's why I say, you have no reason to believe this. Why? Because there is a way of presenting conclusive evidence to demonstrate that actually the applicant is as errant as he's being portrayed. My lord, with respect to the question from my lord CJ, the serious consequences, and that the matter is not before this honorable court for trial, but to consider whether to grant or not to exercise your discretion. First, I reiterate the first answer of the veracity of this, which is left hanging without an attachment. But the consequences, yes. As a lawyer, I know, and I submit that it is the duty of us all to give due respect and treat this honorable court, not only this court, but any court or institutions of state, with decorum, as to whether this should be used or applied or looked at in the exercise of the discretion. That's why I'm submitting no. Why? Because it is left hanging. You have no reason to believe this affidavit of Mr. Oscar Chihika that the petitioner stroke applicant is in the conduct of disparaging and disrespecting court. If anything, the evidence supplied by the Attorney General, which I agree with, my client is a regular user of the courts of law in this country whenever his rights have been transgressed. That is a demonstration that he believes in the rule of law and not jungle law as is being presented. I mean, there is evidence on record.
You know what the learned Attorney General said, I think the other person said, that your client is only happy with court if the court rules in his favor. The moment the court rules against him, then the court is the other words I cannot repeat them.
That's what he's saying, but I'm giving the proper context. And the proper context in our humble submission is that the applicant is an added believer in the rule of law. That's why, whenever brutalized, whenever transgressed upon, he runs to the same court. He's not running to anyone else. What the effect of the submission from the respondents, from the bar?
But when the court rules against him, then it goes to the people's court. That is the final court now about the Supreme Court. That's really what it means.
In my lord, in the honest belief that you have not believed that rumor, my lord. I know.
Councillor, I want you to know the presence of the other thing. But let me say this. As a Catholic, people pray a lot of things. For me, Jesus said, we say the Lord's Prayer. I say it twice every day. And one week I remember, it says even God should not lead us into temptation. I think do not lead the Attorney General, who has said he wants to organize a meeting, which is a very good thing. Don't lead them into temptation. Because for me, I would want this matter to remain very.
My lord, I treat
and we do our things.
with immense respect, my lord, to the.
Don't emphasize that area. That's very good.
No, I think.
I don't know. I'm just realizing.
My lord,
that's why I was helping you.
May I pray?
That route. Let us conclude this matter. Whatever has happened, then we begin. Then we continue. As the judicial representative which I hate, we were never influenced by people who praise us or people who abuse us. can abuse the Chief Justice, you can abuse the justices of the Supreme Court, or the entire judiciary. But when you come before us and you're on the side of the law, we will protect you. The insult you've hit on us notwithstanding.
My Lord, that gives me comfort that actually you're not aware of those insults because they do not exist. And if they existed, you would have evidence before your lordships. My Lord, that's my prayer. And that's why I said that the matters placed here are extraneous to the extent that somebody simply comes to say, this man said he's going to the People's Court. I agree with the counsel for the first respondent that this is the People's Court because it is established in accordance with the Constitution to exercise jurisdiction in accordance with the aspirations of the people of Uganda. As to whether, my lords, that is the perception of either the petitioner, the respondent, or other people outside, is not a matter for this forum. Like I did make an undertaking, anything that ridicules the independence and respect of this court, I stand with the court. Thank you, Madam. With respect to cost, thank you, Madam. I think something again prejudicial has been said about the petitioner and his advocates. Let me repeat. As advocates, we have done our work in accordance with our professional training and orientation. My lords, a lot has been said in the background. May I invite court to look at that as a background, notwithstanding interpretation on the part of the parties, but the essential elements to satisfy you in exercising your discretion have been satisfied and placed before your lordships, that there is good cause to withdraw, to allow the withdrawal of this petition. I think a lot has been said about costs.
In 5 minutes.
With respect to costs and the prayers. First, it is no admission of offenses on the part of the applicant. Anyway, the alleged forgeries are a concoction by a person who is being strangled before this court and trying to look for evidence to extricate himself. I believe it was within the right of the respondents to extricate themselves. But to the extent that they refer to the signatures as forgeries without bringing conclusive evidence is also very, very unfortunate. My lords, on the prayer by the respondents that you be pleased to therefore declare in accordance with Section 59 of the Presidential Elections Act that the first respondent was duly elected. The guiding law is subsection 4 of Section 59. 1. It reads, where no petition is filed within the time prescribed under subsection 2, where the petition having been filed is withdrawn by the person who filed it, or is responded, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected. You do not need to make a declaration. It is not within your power. It will be up to the person was already declared by the Electoral Commission.
What does the law say? The law says
there are two provisions, and I want to read both of them.
Please do.
5. After due inquiry under subsection 3, the Supreme Court may dismiss the petition, declare which candidate was validly elected, or annul election. Now, your power to declare comes into play under subsection 5. After you have had due inquiry into the petition. The process in subsection 4 is purely a political process. It is up to the respondents to say, since the petition has been withdrawn, therefore this man was properly elected. For you to order or to declare that the first respondent was duly elected, it can only come under 5 after you have inquired into the petition, which, for now, if you permit the withdrawal, you have not done. My lords, finally, on the issue of costs, I reiterate my earlier prayers, but let me conclude with this particular extract from the decision of Justice Ssegona, JSC. In our bundle,
Do that in 2 minutes.
thank you, Lord. In our bundle, pages 17 and 18, it is express. My Lord, this is election petition number 1 of 2001. He says, even if, and quoting the Indian authority of Charan Lal Sahib and others versus Singh 1985 LRC, page 31, that even if the election petition was frivolous, court should exercise its discretion not to award costs because of the public importance of an election petition.
Does that cover even a vexatious one?
It does.
What your learned friends are saying in their instance, I'm not saying I agree with that. But what they're saying is that the petition was both vexatious, the petition was both vexatious and frivolous. That's really what they're saying.
My Lord, that will take us into the definition of both phrases, vexatious and frivolous. One which does not disclose on the face of it reason for inquiry. If that was the kind of petition we presented, it would even have been one either rejected by the registry or struck out by way of a preliminary objection.
That would be a cause of action, and not a cause of action. But it will still be very vexatious and frivolous.
Yes, my Lord, in this case we submit it was not, to the extent that it demonstrated.
But what I wanted to know,
Yes.
I'm not ready to say,
Yes.
it would cover what situation.
It does, it does. Even jump to us causes, my Lord, it would be covered. My Lord, the second respondent has submitted that Ukasha Sekaja does not have.
You remember you had 2 minutes on.
I'm now using the last one, my Lord. Does not have knowledge of the procurement issues. The first thing is, what does the law require? The law requires a procurement process which is public, including an advert, for all lawyers who may wish to supply. It is no record that it was done. But the authority I referred to, which I invited you to adopt and find persuasive, of Justice Musota, involved the same law firm of Kampala Associates and Advocates, of procuring legal services. There was an opportunity. It is not true that they could not respond because this came by way of rejoinder. The practice of court is that there is even a surjoinder, there is even an affidavit in rebuttal. There is even a provision for somebody to apply for leave to respond to a particular averment. It is also not true that this is so contentious. No. Every lawyer knows the procurement processes and laws in this country. And I want to assure lawyers that really went through law school. And Ukasha says, I know that this process was not followed. It is illegal, it is irregular, it involves the same.
I'm trying to understand. So your point is, even if this court were inclined to award cost, then they cancel the provision for instruction fee and the other costs which are attendant to cancel it. discretion and so on should be
They would not be entitled to a coin.
But that does not mean the second respondent, is it second? Yes. Will
First,
not be
the second,
entitled.
the first and second.
Okay, it doesn't mean they will not be entitled to cost.
No, it doesn't apply. Not in my submission, I said specifically with respect to the second respondent.
But this is what I'm saying.
Yes.
Would it mean the second respondent will not be entitled to cost? Or if it is being taxed, the lawyers who have represented it here will not be entitled to cost?
My Lord, that's why I submitted that to the extent that the procurement was illegal. Now, the second respondent, which costs would he present, or would it present? And this was in specific reference to the affidavit of the
No,
Honorable Stephen
the
Ssegona.
second respondent answer. The second respondent is here in the person of
Honorable Stephen Ssegona.
Commissioner Tashobi, yes. I mean, I don't know, maybe the other, all that I need to know
Oh,
is,
my Lord, you're
are
referring.
you saying whatever other cost, inclusive of hiring counsel, they will not be entitled, or are you saying whatever other cost which can be permissible, if court is inclined for that cost, they will get it, but not for hiring.
I'll give two answers in the alternative, my Lord.
Yes.
The first is that they would not be entitled to anything for having engaged in an irregularity and illegality. But in the microscopic event that you find they should get something exclusive of the instruction to advocates, then I would concede to transport to Commissioner Stephen
No,
Tashobi
no, that's not for us.
as a disbursement.
Answer the question now. So what is your final prayer?
My final prayer, therefore,
Reiterating your earlier prayer.
to reiterate. No, my Lord, I'm talking about the denial in principle that the taxing master should not even entertain a deal from the second respondent. Finally, my lords, we have mentioned that my colleagues, counsel for the first and second and third respondent, have submitted, and I'm winding up, that that the provisions of section 64 with respect to liability to
You would begin by asking you for more time.
My Lord, may I be granted half a minute?
I'll give you 2 minutes.
Thank you, my Lord.
Please conclude. Half a minute, you yawn and what
With respect, my Lord, to the question of liability to pay costs as per section 64, liability to order costs simply means this honorable court has the discretion. It is not mandatory, as submitted by my learned friend, Mr. Edison Karhang, that where the state shall be liable to suffer, to pay costs, it is mandatory. No, the word liability connotes that discretion. But even the word shall itself is not mechanically mandatory, as he thinks or he seeks to submit. Authority, my lords, number 5.
What is mandatory in that one would be liability?
There is nothing mandatory in
If
that.
you say it shall be liable,
Yes.
what is mandatory would be the liability,
No.
not the cost.
No. What is
Not the
mandatory?
suffering of cost.
No. Nothing is mandatory in that, my lord. And the authority number 5 is a decision of this court, Sitting Sevalu versus Sam Kenjuba and the Electoral Commission. This honorable court, and my lords, I refer to pages 50, specifically page 55, on the interpretation of that word has been made. And that's why, my lords, even in previous petitions, you have not awarded costs. I pray that you continue to exercise your discretion judicially.
Yes, because it is mandatory for court to exercise discretion
Obliged,
on issue of cost.
obliged, my lord.
The discretion, it is not something they come and say, we have awarded cost. We have not awarded cost.
May I rephrase that? Yes, it is
Exercise
mandatory.
of discretion is what to be done judicially.
True, my lord.
You know that what it is.
That's why I'm saying, my lords, and I emphasize the word that you continue to exercise your discretion judicially.
Thank you.
I so pray.
Thank you so much. I think there's a question from Ireland.
Master Ssegona, there was an authority which was supposed to be roasted. Where is it in the process? Have you abandoned it?
No, my lord, after roasting
When
it,
it's a registry, I think one is
my lord, after roasting it, it could not come back to the same suspiciously contagious hands
No, it was
of the royals.
But is it on the record?
I believe yes. We filed it in the registry, and it is, if it is not there, my lord, it is in
I
transit.
think it's okay. That's
Thank
the first question. Then I have a question for counsel for the second respondent. Counsel Karuham. You submitted that, and I'm glad it has been touched on in the rejoinder, and the court has also talked about it earlier. That paragraph, there are vermins in the counsel for the petition, applicant's affidavit regarding the issue of procurement and not within the personal knowledge of the person, the counsel, and therefore they should be struck out. That's what you submitted.
Yes, my lord.
So my question to you, my reading of a vermin in this application, and I think it was this application, there are many other vermins which fall in this category. Is it your position that court should severely strike them out?
Sorry, my lord, there are many other, I didn't get the...
Vermins which have been made, and time does not permit us to go into them, which would seem to fall in that category. Sold by
Kasha Sekaja, my lord.
yeah, no, the ones sold by Kasha, your submission was that they should be struck out for they not being within the personal knowledge of the person deponent.
Yes,
So
ma'am.
my question is that, is it also your submission that the court should apply the same standards to any environment where deponents have deponent matters that are not within their personal knowledge?
My lord, I think if I can just...
So with respect, for example, to your client, because I'm going to ask the same question to
Yes,
the second respondent, is that your position?
yes. My lord, our position is that the law governing affidavits is Order 19 Rule 3. In that particular affidavit, he deponed in his capacity as counsel for the applicant and said he knew about certain processes of the second respondent and did not show how he knew about him, where he had been informed about him. If there is any other affidavit that contains information where
From the
someone does not
respondent,
show
yes.
that he knows how he, when he does not disclose the source of his knowledge or how he obtained it, it would certainly violate Order 19, Rule 3 of the Civil Procedure Rules. I think the ultimate principle is where a deponent is giving us information that the deponent surely does not know, like Mr. Sekaja does not know, then you cannot rely on evidence that a witness giver surely does not know. As opposed to someone who said, I heard, I
So
saw.
you agree with me that that's a rule of general application. It applies to affirmance by the applicant, and so it also applies to affirmance by any party from the respondents.
Yes, it applies. I speak for the second respondent, my lord, it will certainly apply. If you find evidence of ours, which our witness didn't know, my lord, please strike it out.
Thank you, thank you. So that takes me now to the Grand Attorney General. You submitted, and this has been consistent, but in this application which is for us, if I may recall, that the affirmance of the applicant that he was restrained and could not prepare for his case were not true. And your evidence in support is the affidavit of the Land Deputy Attorney General, right? Which shows that the applicant was able to access, and you mentioned two in particular, his lawyer and his close associate. Okay? So my question is that if the applicant says I was not able to access whoever I needed to access to prepare for my case, was the Land Attorney General within the personal knowledge, okay, of who the applicant could have wanted to access to prepare for his case? Was that within his personal knowledge?
Thank you very much, my God. If we look at paragraph 4 of the Honorable Kafuzi's affidavit, in reply to the notice of motion, that is where he states that it is not true that the applicant's mobile numbers were disabled as alleged, that I know that the applicant's advocate, ex Juliana and Geoffrey and Zaki Francis, a close associate of the applicant, disclosed in their affidavits that they were communicating with the applicant on his mobile phone during the time when his movements were restricted. His basis was a disclosure in their affidavits.
Yeah, but you use this, the concern I have is that you use this statement to make a general claim. Because one of the reasons the applicant is giving is that he gave the reasons why he couldn't, he's withdrawing, right? And part of it was the inability to access, which has continued to be, has continued to resurface. It resurfaced in the application for amendment. It resurfaced in the application for leave, file extension of time, file additional evidence, and it has also resurfaced here. Is that correct?
The question of his restriction?
Yes.
Yes.
And your answer has been consistent that you are relying on the affirmance of the Land Deputy Attorney General. In one of them, a list saying, yes, he accessed his lawyer and he accessed close associate.
Yes.
So my question is that statement, accessing the lawyer and the close associate, is that sufficient for you to make the claim you have made here that the applicant's affirmance about the effect of his, the restriction, the 10-day restriction, had an impact on one of the reasons why he's saying he's withdrawing?
Well,
Is there is it right to transfer, access to one person to say, because of this, therefore, he had access to everybody who wanted to access, to prepare for his petition?
well, all we were doing is that
So those are your submissions like that.
on which I have already told you, Learned Justice, that the affirmation in Honorable Kafuzi's, I've told you his source of the information is their affidavit. And that was in response to the fact that he did not have contact with to give instructions. So I'm saying that on the contrary, and by his own affidavit, he had contact. That's what it is.
No, but does the law say that an intending petitioner, once they have contact with one of the people, that is sufficient? Is that the law? Can you cite any provisions
Well, I don't
which you
know,
are relying on to make that assertion?
but I don't know whether a law gives a number of how many there must be.
No, my question is, do you have any law to make the assertion that if a petitioner says, I was constrained and couldn't access whoever I needed to access to prepare for my petition?
Well,
Then the Land Attorney General says, no, you had access to two people. One, your team which you instructed, and the second one, your close associate. Do you have any basis, legal basis for making those assumptions?
Well, the basis that we have is that he had contact with his associates and his lawyers. That's the basis that we have. For example, he made some affirmance that his witnesses were abducted and harassed. Like I already said, he does not provide any evidence of who these persons were of serious offenses. He does not give any evidence of the names of the people who were detained and therefore who made it impossible for him to present his case. Because had he done so, then we would have had the opportunity to controvert. That's what we're saying.
So, anyway, I think I took the answers I needed. Thank you.
Any other question?
Thank you, Married Council, for the parties. We've been consulting within ourselves. We'll give a short ruling, which will be read out by Lady Justice Arata Amo. Ms. Barrett.
Thank you, my Lord Justice. This is the ruling of upon careful consideration, the application, the supporting affidavits, the submissions of land council for the parties, the authorities relied on and the law, and considering that the respondents have no objection to the application for withdrawal, leave is hereby granted to the petitioner as read. The petition stands withdrawn. The reasons for allowing the withdrawal and the reasons and the determination of the issue, of course, shall be contained in a ruling to be delivered on notice. This ruling is signed by all members of the forum. Thank you.
Learned Attorney General, why my lords signed this document ruling. You brought up a very important matter that we have the sittings and forum with council, not just council here. I think we should include members of the press as well. The reason we have this fully covered is because this court belongs to the people. Everybody who cares to know what is happening in this world and has the opportunity should be able to follow, even from their sitting rooms, offices, their joint, and so on and so forth. So it's really important that for the good of the rule of law, for the good of due process, you will need some discussions on our respective responsibilities. We as the judiciary, officials of the court like United Council, and members of the media, who have the responsibility to let the people know correct factual information and what is really happening in the court. So that's the only way we can do justice in all the matters that are before us. So in that sense, please, widen the base. The catchment area should be widened.